Hey, good morning, everyone. Welcome back. It's a fabulous Friday here at Law and Legitimacy, and I'm in the Hotel California. I'll never be able to leave. Here we are on day 56 of the Proud Boys case, and if you read the paper or the media online, you saw we had a very brief and what I would say disappointing hearing yesterday. Incident to revelations that a defense witness that was going to be called by counsel for Enrique Terrio might in fact have been was in fact a confidential informant at various points during the case. She appears to have been cut loose from her informancy, as it were, once her name appeared on one of our witness lists. But while she was an informant, she was talking to my client, she was talking to defense counsel, she was trying to arrange change of counsel for some folks, and she had plenty to say about the case and who should be called as a witness. Now, the federal defense to this, and all of this would be a shocking Sixth Amendment violation of the right to counsel if she were sent to engage with represented clients and their counsel and learn about the trial and the trial strategy. If she were sent by federal officials and if that information found its way back to federal officials, that's a big problem. But the federal defense she was informing on something else, and she was a free rider, and we didn't know anything about any of this. Well, that may be true. And so there will be further proceedings and perhaps an evidentiary hearing. It was my hope that the proceedings would be stopped while we sorted this out, but Judge Kelly was having none of it. I think from his view, we had 12 days of jury selection, 44 days of evidence and related proceedings. And if I've learned one thing, never get in between a judge and a disposition. A lawyer has a good day in court when he wins, a bad day when he loses. Judges don't win or lose. They only have good days, and good days are when they close a file. And I have a hunch that this case is as big a headache to Judge Kelly as it is to the lawyers involved. Yesterday, it was quite a sight in the federal courtroom. There were, the 5 prosecutors on the trial team, 2 senior Justice Department lawyers came in to intervene as the so-called taint team. And then there were other people even more senior from the Justice Department in the crowd. The joke last night was, what's next? Merrick Garland? Well, it would be nice to see him. Maybe they could even rouse Joe, but he'd have to get up before 9 to get into court. And, there are some steps that he'd have. Well, actually, there aren't. He could take the elevator, so he could probably get there without falling and hurting himself or nicking his chin, as I did I'm shaving this morning. So anyhow, we're back at it today. There will be fireworks to come, because of the rule against extrajudicial, prejudicial pretrial publicity. I can't talk about it. And I know that some of the people who attend the trial listen to this podcast, because I walked in the other day and a guy had headphones on and he said, wait a minute, wasn't I just listening to you? How can you be here? And I'm like, I don't know. I mean, I'm here. That's all I
Magic,
do.
Baby.
Magic.
I have a question for you. On the CHS side, the confidential informant side, especially at the federal level for the FBI, what types of individuals compose that pool of, I guess, informants? Who are we? Are we looking at criminal defendants that have, pled to something or offered themselves in exchange for whatever, or are these, just people that wouldn't even necessarily have been under scrutiny by, law enforcement?
Well, the simple answer is we don't know, and we can't know, because the database of registered CHSs, confidential human sources, is a closely guarded secret by the FBI. And what I've learned in this trial is that the FBI maintains a database that is well guarded, highly regulated, and very few folks have access to it. And the shocking thing is that investigators investigating a particular crime or prosecutors preparing to prosecute a particular case themselves may not have access to the list of CHSs. So we live in a universe in which it's possible that the FBI is sitting on information that could be valuable to an ongoing criminal investigation, that could be valuable or even exculpatory in an ongoing criminal prosecution. And the prosecutors and the defense don't know it. And the reason for this is, in the 1970s, the reasons are multifold. In part, a confidential human source, you say what type of person it is, Mike. It's a person who has information or access to information that may be of value to the FBI. And, if it's a drug operation, it could be a person in the organization itself. If it's a campaign fraud case, it could be a person in the case. If it's a white collar crime case, it could be the guy sitting at the desk next to you. And the FBI wants to keep their sources confidential for several reasons: to assure their safety, because all is not, shits and giggles, excuse my language for those of you who have your children in the car. All is not fun and games in criminal defense land. It's a fairly intense universe, and a person who's known to cooperate with the feds may or may not face safety concerns. If they're burned, that is, their identity is made public, they become less useful to the FBI. So I think that depending on the investigation, there are all sorts of people in there. And a confidential human source, a CI, an informant, is to be distinguished from an FBI employee. While they may be compensated for their work, they're more like independent contractors. They get fees, for the work. They have to submit invoices to the FBI or requests for payment, unlike an undercover operative. An undercover operative may be an FBI agent posing as someone else who is directly on the payroll. Now, the issue that makes this explosive, at least in my mind, and it's something we've talked about several times this week already, is how involved is the FBI in recruiting, paying, handling? Because a CHS has a handler in the nomenclature, in the trade. This is a full-time FBI employee to whom they report and who instructs them on what to look for and what they can and can't do. And they can obtain authorization from the FBI to engage in illegal activities. This is part of the CHS process. So if you're running with a motorcycle gang, and they're out there breaking windows at night or breaking the legs of their adversaries, you can't very well credibly pose to be a loyal member of the gang by saying, "Oh no, I'm too fastidious for this." And so, and sometimes CHSs are cut loose because they've engaged in unauthorized criminal activity, or if their criminal activity was authorized to one degree, they take it to the nth degree to be self-serving. So it's a complicated, murky world. The public doesn't see much of it. I'm very, very troubled by the use of CHSs in developing intelligence and information about domestic groups, because as we saw in the 1970s with respect to the left, the FBI was not above using sources to try to disrupt left-wing groups for political reasons. And I think that the FBI probably has, well, I know the FBI has CHS is embedded in right-wing groups that they have denominated either domestic terrorists or people of interest to the FBI. And this may include even parents protesting at school board meetings. If you're going to be going to your local school board to complain about the curriculum, you don't want your kids being taught critical race theory, and you attend a meeting and there are 10 people in there, is that ninth guy who you don't really know that well really just a parent, or is he reporting to the FBI? I don't want to live in a world where I'm looking over my shoulder, wondering whether Big Brother is listening and building a case against me just because I'm a critique of the regime or a critic of the regime. So, here we are. That's the world we live in. That's the world that the public is we're trying to get a little glimpse of in the Proud Boys case. Yesterday we called for the judge to require a senior FBI official to come in and explain how this database is managed and how it can be possible. I
saw Brandy Buckman was live tweeting all of this yesterday as well. She was there for the 3 p.m. Hearing, and I think you said, she referenced that you called for the FBI to be audited over this.
Right. I mean, I want to know, and I think Jim Jordan and his weaponization of Congress committee should be all over this, and should be studying this trial transcript, and should be asking significant questions. To wit, how is it that weeks, months into a high-profile trial, even the prosecutors are surprised by some of what they're learning? I wasn't. One of my colleagues was cross-examining an FBI agent about a confidential informant when one of the prosecutors came up to her and said at a break, "Where are you getting all this information? We had more information than the FBI about the FBI's confidential informants." or at least more information than the prosecutors. And if the FBI is sitting on information it's not sharing, and some of it's potentially exculpatory, that's a big problem.
Yeah.
So we don't have answers, and we're trying to get them. So stay tuned.
One question there. I recall at the beginning of this case, there was much ado about preparation for trial because of the sheer volume of discoverable information that was being pushed back and forth. Of course, you've got incarcerated defendants, so there's difficulty with respect to their own review of particularly video and other information. And my thought was, well, we lost Norm. Where did Norm go? Maybe he'll come back. I'll just be here for all of you in the chat. We'll just talk to each other. How are you? Lawyer Will, tell me something good. Maybe Norm will come back. Oh, there he is.
There's a lot of, I don't know what I did. My hand grazed.
So what I'm getting at is when you say that, how are we months into the trial? Today is day 56. How are we this far into the trial? And then this is something that can occur that way. Could this be looked upon as evidence that perhaps the trial start date should have been further delayed?
Well, maybe, but the problem with that is there's so much information on that analysis. The trial should never occur because they're I heard
that notwithstanding, right? And also, the incarcerated individuals being there longer without a trial starting notwithstanding. So I'm aware of those two things.
I heard a federal prosecutor in another J6 case tell a judge that there were 250 terabytes of information that the FBI had collected. I don't even know what that is.
Ungodly.
But, it would take years for a team of people to review all the videos that are out there. So, everybody's doing their best with, the government hired an accounting firm to create a database, a searchable database that everyone can use. You're offered opportunities to take classes on how to use it. You use your search terms and you find what you find. Now, the question is everything been well classified? Are items misfiled? Did everything make it into the files? You just don't know. And in the case of United States of America versus Biggs et al., I do not think the trial should have gone forward because at the very moment we were beginning to pick the jury, the House January 6th committee released its report, its 800-page report. And the House committee did not share with federal prosecutors all the information it had. And so there is substantial doubt there are substantial questions in my mind about whether we have everything we should, but I don't have time to find out. I mean, there's trial every day. We start court at 9. We go sometimes till 5:30, 6 o'clock. There are only so many hours in the day. And so we're doing the best we can. I've now learned the expression sipping from a fire hose. That's what we're doing.
Yep. Well, and I don't know that there's any real answer, just sort of, observing the process within this case. I've learned that, justice is very, very hard earned. So I guess from all of us to you, Norm, thank you for the work that you do.
Oh, everybody does the hard. All lawyers work hard. That's the way it is. Hey, let's talk about Ethan Crumbley in Michigan. Fascinating case. Ethan Crumbley, you will recall, I don't recall the year, but was a school shooter. And he
2021
shot, I think, 4 of his classmates in the Oxford, Michigan high school. And his parents have been charged with involuntary manslaughter. So he's a 15-year-old boy. I don't think prosecutors or the court has yet determined. That's a chilling photo. I don't know that prosecutors have yet determined whether he will be charged as an adult or not. But his parents are now facing involuntary manslaughter charges, and their lawyers, his parents' lawyers, Mr. Crumbley's lawyers, took their case to the Michigan Supreme Court, which ruled yesterday, or this week, I gather, that there's enough evidence, and it may not have been the Supreme Court. It may have just been the appellate court.
State of Michigan Court of Appeals.
Okay. Both Mike and I read the decision this morning that court has held that there is enough evidence to get the parents to trial on an involuntary manslaughter charge. And it did so in a ruling that raises chilling questions. So here, Mike, why don't you go through the facts? What did the parents know about Mr. Crumbley in the days, weeks, and months before his shooting?
Yep. So just to back up a little bit, Ethan Crumbley is now 16 years old. He may be even 17, but he actually pled guilty to 4 counts of first.
Oh, I guess I was wrong about that.
He pled guilty to four counts of first-degree murder. So
Okay.
that's still pending. However, this criminal probe into the parents didn't take very long to begin, and in fact, it's gone to the district court level, and then the first appellate review of that. I guess the circuit court there in Michigan upheld the district court's ruling to charge the parents, and then the Michigan Court of Appeals has yet again reaffirmed the district court's finding that the parents may lawfully be brought upon charges of involuntary manslaughter. So, backing up with the facts, this is over basically the facts of the that are referenced in the Court of Appeals opinion start around March of 2021, and they profile Ethan as a bit of a loner, right? Somewhat despondent. He lost a grandmother, a dog, one of his friends moved away. There's some relevance of like a 22 handgun. Now, the murder weapon was a 9mm Sig Sauer that his father had purchased just several weeks before, and it was an early birthday present for a 15 or a 16-year-old Norm. So there's some interesting facts there. The mother, I think, is someone in marketing at a real estate firm. The dad actually just drove for DoorDash. That was referenced as his job. But what was very clear is that the two parents, James and Jennifer, were not really around that much from what I gleaned, right? There was a lot of discussion of the fact that, Ethan would text his mother in particular, and he was having some psychotic or some mental.
Yeah, I mean, I think you're soft pedaling the mental state of the kid. I mean, basically, this is I'll call it the cry for help case.
Yep.
This is a kid who thought demons were in the house. He thought that things were flying off the hook. He was feeling suicidal. He was begging for help. He was, and I think the very day of the shooting, he's in school on a math exam, drawing pictures of a gun, of a bullet. When questioned, talking about it as a video game. He meets with his parents and a school psychologist or a school administrator. The parents don't even give him a hug at the meeting, tell him he'll be all right. He's asking for help. His father says, suck it up. His mother wants him to come home. She's not taking him seriously. As I read through the Michigan appellate court decision, I got angry at the parents. I thought they'd been given the gift of this young boy's love and life, and they almost seemed too busy, too self-involved, maybe too overwhelmed to care. Now, I realize that's not a prosecutor's brief. That's the appellate court's brief. So I assume that they tried to be reasonably fair and call it as they saw the facts proving it. But I think the Michigan prosecutor's concern was that here was a young man who seemed to be collapsing and who seemed to be crying out for help. And it was obvious to school officials that he was behaving in ways that raised significant questions about his stability. And those questions were even more pronounced at home. And when given notice of that, his parents ignored him and basically didn't do what I think most parents would do, which would be to get him some help. And so he walks in the classroom later in the afternoon, or at least on school grounds, and kills 4 people with a gun his parents bought him while he was behaving in such a troubled way. And so, from the law's perspective, Ethan Crumbley is the shooter. His mental state could have been at issue at trial. I'm sorry, I forgot, folks, that he had pled. I thought that there was a decision yet to be made about whether he'd be charged as an adult. So he's pled guilty. Apparently, they evaluated a defensive mental disease or defect and ruled it out. But he's behaving in a way that's highly disturbed. And where are his parents? His parents are absent without leave. And so prosecutors concluded that they were guilty or are guilty, or there's probable cause to believe they are guilty of involuntary manslaughter, meaning that they placed their son in a position in which it was reasonably foreseeable that he would engage in homicidal acts. And can
we back up just a little bit here? So, Norm, this what I've got on the screen is what Ethan. Now, there were multiple instances in which Ethan came into contact with school employees or administrators for certain behavior. In one case, before this is before the shooting occurred on a different day, he was found looking up ammunition on his phone in class, and that was reported. There was a discussion about that. He was called to the office. There was a phone call placed to the mother. They said, you don't have to call us back, but we did this. And then there's reports of the mother texting with Ethan, save all the detail. But at the end of that, she said something to the effect of, you just got to learn to not get caught, right? Because
that's right. She did say that.
The kid is downplaying the severity or the seriousness of the issue, right? And then what's really interesting about this to me, before we get to the legal mechanism of involuntary manslaughter, because for whatever reason, I am just drawn to the whole sort of negligence analysis that is applied in the criminal context. But in this, you can see on the screen, this is the math worksheet that he had completed that morning, 8:59 a.m. The shooting didn't occur until sometime shortly after lunch, and after Ethan had met not only with his mother and father, but one of the administrators in the office at school. But this was drawn on the same exact day. So this is in math class, and I'll scroll down. When someone made it an issue, this is the version of it afterward, right? So the teacher was able to get a picture of it, and then Ethan subsequently tried to efface some of the more troubling features of all of that, right?
And when questioned about it, he said, look, this was like his fantasies or ruminations about a potential video game. He was considering a career in video gaming.
Well, look, the thoughts won't stop. Help me a picture of a very detailed version of a handgun that is going to be a Sig Sauer, right? So this isn't something that he's just, looking at without being unfamiliar. You've got blood everywhere, a picture of a bullet. My life is useless. The world is dead, right? And then on the subsequent one, video game this is. OHS, Oxford High School rocks. I love my life so much. Harmless act. We're all friends here, right? I don't understand how this wasn't absolutely for everybody in that room, but that is what the court ultimately started to look at, right?
Well, so I think Mike, in our discussion before we got on the air, you raised questions about the school district's liability, and so with the schools seeing this, should they and could they have done more? And the answer may be yes, but let's focus on the Michigan Appellate Court decision for a moment,
sure.
And the legal mechanics of this case. So in order, to commit a crime, a person has to have a guilty mind and has to commit a prohibited act or fail to do something that the law requires. So in this instance, the court held that the parents obviously had a duty to their son, and that they were willfully blind or neglected him. And they neglected obvious signs of his cry for help and how disturbed he was. And as a result of that neglect, the court held others were killed. That their neglect, in effect, served a role in causing the death of others. And that's the linchpin of this decision. The parents' lawyer said, wait a minute. Ethan was what's called a superseding intervening cause. So let's break down causation. This is Law 101. Those of you, who was it yesterday who wanted to know how to understand a little bit more about the law?
Thinking Man.
Thinking Man. Is he here today?
He hasn't said anything. So if you're here, Thinking Man, raise your hand.
And if you're not, you're absent without leave, and you get 1 point off. So, in order, events don't occur spontaneously in the world, at least from the law's perspective. To become interesting in the law, somebody has to be accountable for something typically, or the question of causation arises. And there are two types of causation at a minimum. There's but-for causation. In other words, but for this event of occurring, the succeeding or later act would never occurred. I got out of bed this morning and I will interact with other people. But for my getting out of bed, okay, I would never have interacted with those people. But for cause is not very interesting. It may be true as a matter of historical fact, but as a matter of law, it's not enough to assign legal liability. What's necessary there is proximate cause, that is near cause that so intimately relates your conduct to the effect or to the event at issue that you can be held accountable for it. And, what does that mean? That's usually a question of fact that has to be tried to a jury or determined by a court. You can be relieved of proximate cause if there's a superseding intervening cause. So a classic example in the Michigan decision was, two guys got in a fist fight once and somebody knocked the other guy over and a horse then fell on the guy, killing him. Was it foreseeable that horse would fall on the guy after the first one struck him? And I think the courts held no. the superseding intervening act was Mr. Ed's rear end on the guy's head or whatever part of the horse killed him. So I think the parents tried to say, however negligent they may have been as parents, the superseding intervening cause was the willful act or the intentional act or the culpable act of their son. And the court held, nah, in this case, there was too much. There were too many obvious signs that something could go wrong. And this event was a slowly unfolding and cascading catastrophe that you should have stopped, could have stopped, and had you stopped, no one would have died. Stopped it, no one would have died. The parents argued, hey, wait a minute. Wait, are we our children's keepers? And of course, the answer is yes. But in the criminal context, should parents be responsible for the criminal acts and behavior of their near adult or their near majority children, or of their children in general? And the court said, we don't think so in all cases. But in this case, the facts are sufficiently grave that it's an open question for a jury. And we cannot say as a matter of law that the child's decision to kill, Ethan's decision to kill, was a superseding intervening cause sufficient to extinguish any liability for the parents. I don't know what I think about that, Mike. I don't know what you think about
so
that.
Just so that we make this a little bit more accessible for our viewers, because Lawyer Will says, so negligent parenting. And I think in a way, yes, but the way that this breaks down any sort of negligence analysis, Norm, you went through one element. Think about this on the civil side. And I think the benefit of arguing negligence in a civil context is that the law has what's regarded as a reasonable person standard. And we've talked about this a little bit before. Criminal law doesn't appear to use that lexicon.
Oh, it does implicitly. Yeah, no, I mean, here it was reasonably foreseeable. That's the claim.
But I'm saying that, there is, in a negligence analysis, there is, duty, a breach of that duty, causation, and then damages. And you usually are going to go in reverse, right? You have the damage, and then you start the analysis of whether there was whether one of the parties at issue had a duty, whether they breached the duty, and whether that breach of duty caused the resulting damage. So the court's indulging this analysis in a criminal context to say, we do have deaths. We have four dead children. We have 6 additional injured people as a result of this kid's shooting. We have him pleading guilty to 4 counts of first-degree murder, which the culpable mental state there, Norm, I think is why the parents' defense counsel leaned so heavily into trying to
I'm sure it is, yeah,
qualify that as, well, clearly he's saying, I meant to do all this, right? So how is it that in that context that we are negligent, right? If that was an intervening superseding cause. But to back up again, causation is actual cause and proximate cause, right? And with the proximate analysis, the court was looking only at whether Ethan's conduct could be qualified as an intervening superseding cause, so as to preclude the merging of all 4 of those elements for a complete analysis in the criminal context. What I was arguing to you this morning is that that's only one opportunity to argue about a superseding or intervening cause, because it's a matter of reasonable foreseeability, right? Was it reasonably foreseeable, in spite of that intervening superseding cause, that the damage would still occur? And what I thought was interesting is that before this shooting, I mean, the stuff is starting in the 8 o'clock hour in the morning, and then the shooting doesn't occur until about 12:40 p.m., right? And in between that time, we've got the images that were on the screen. We've got the text messages and phone calls to the parents. We've got the meetings with the meeting with the parents in there. The court says that at no point was his backpack checked or any of this stuff. So what I am saying is that in today's culture, in late 2021, school shootings were not, an anomaly in terms of fact patterns for school administrators and what we look for. Now, we can debate about whether, schools are taking the appropriate measures or what the appropriate measures even are. But there is a pattern of behavior with this particular student. And the fact that the school had custody of him all day and had brought the parents in, and yes, the parents didn't take the opportunity to leave with him and extract him from school, that would have prevented the shooting at the school. But I still believe that it's not, that there's a colorable argument to be made on behalf of the parents. Now, look, for everybody listening, I think these are, I can't imagine being this disconnected from my child or children. I just can't. And for that reason, Norm keeps, pushing himself off the screen, playing with stuff. From that context, I don't want anybody to mistake what I'm about to say. But in terms of exercising the legal merits of this case, I think that there is a colorable argument to be made that at the point that you have this sheet of paper with this pattern of conduct, right, with him looking up, 22 caliber bullets, telling other administrators in the first meeting that he had gone to the shooting range with his mother. So we know they are all aware that he knows how to operate a firearm. He's doing all this stuff on the page. Why is it that nobody even takes the opportunity with the parents there to say, hey, do you mind if we search your son's person before we send him back to class? Otherwise,
no, these are great questions, and and you have persuaded me that there may be a cause of action against school administrators. But here's my response:
saying that from the negligent homicide sort of thing, the involuntary manslaughter type of thing, are we going to allow that to attach even when there was something as present and as salient as an all hands meeting?
Well, here's my
return to class and shoot somebody that day after everybody had custody of this kid at that point.
Here's my response, and it's a simple one. If you're a parent and you send your child to school with a ticking time bomb, is it the school's fault that they didn't stop the bomb from exploding?
I don't know.
I don't either. And I think that's one of the questions this case presents. I think that would be a hard defense to put on for the parents, because that would be my answer as the prosecutor. The parents contend that they sent this ticking time bomb to school, and the school officials didn't hear the ticking or didn't do enough. Who sent the kid to school with the ticking time bomb in the first instance? So I don't know. I hear Lawyer Will's point about negligent parenthood. Is there a crime for negligent parenthood? And I don't think there is. I think this case represents an outer limit. There was a case in Connecticut years ago. A young boy killed himself. And when the young boy, I say 12, 13 years old, an investigation was done, and come to find out that the mother was slovenly. She kept a very disorderly house. The dishes were never done. There were cockroaches everywhere and all this other jazz. So she ended up getting charged with risk of injury to a minor. Under Connecticut law, risk of injury to a minor is when a person does something that undermines the health, education, or welfare of a child. It's a felony carrying up to 10 or 20 years, depending on whether there's sexual conduct involved or not. And that conviction, and she was convicted, and the court overturned it, basically saying it's a little bit too remote, too tenuous. It's hard to go from a sloppy house to suicide. This case is a closer hit to me. I don't know that I would have permitted it to go forward were I a Michigan appellate judge, but I think I can see why they did.
Sure. And of course, that the court went through, I don't want to say great lengths, but they do acknowledge in pretty decent detail that there's a framework whereby this won't be, unreasonably expanded to charge parents where the facts are not such that they are so connected to the outcome, right? Because
there's a saying in the law that bad facts make horrible law. And so here's a really bad set of facts that now has created a proposition that parents can be charged for the crimes of their kids. And so the appellate court has opened a Pandora's box that's now going to have to be litigated on a case-by-case basis as aggressive prosecutors take this legal doctrine and try to encompass more and more facts within it. We talked yesterday in our question and answer thing about legal doctrine and about how courts make decisions and they hold that certain things are the case, that this case can go forward because of a rule that they announced. And now prosecutors will see that rule and they'll be inclined to try to apply it to different fact patterns. And the court's going to have to struggle with how broadly to apply that rule. And as a body of law, a set of decisions emerges, some doctrine that might serve as useful in the future may emerge. Keep an eye on the Crumbley case. And Mike,
I'll end by saying this. I think that the court at the beginning talks about the standard of review, and they take care to distinguish between de novo review, that is, there is no deference to the lower court's findings of fact, etc. And then there is sort of an abuse of discretion standard. And this ruling was an abuse of discretion standard. In other words, the court was looking to see if the lower courts clearly departed from what was expected of them in an analysis. And for that reason, they didn't find it. So I think that procedurally, this was set up to fail a little bit, because an abuse of discretion standard when it comes to a court reviewing another court's decision-making is inherently a more difficult proposition. But secondarily, I won't say this is just them allowing them to go forward with it, because that is, I think, is an issue in and of itself that we were just speaking to. But there still is the prospect that the parents have defense counsel competent to make the argument that cuts off liability for that proximate cause analysis at trial. So we'll stay on top of that.
We will. And listen, I hope you weren't offended. I didn't realize I was playing while you were talking, because I was learning how to manipulate the banners and tickers. And I didn't realize I had the ability to do that. I thought perhaps I was going to have access to the live stream comments. And so, I look at what I can do, folks. Look at me.
Yeah. Well, look, it will get you next. We'll have a second tab open so you can check on the chat, because that's, right. You go to the actual video on Rumble. We can see everybody in here. Thinking Man, Lawyer Will, Pete Atkinson is here this morning. T-Girl wants to talk more about the Twitter files. I think she's correct. So we'll focus on that coming into the new week on Monday. But overall, I've enjoyed this week, Norm. We've had our most successful week in terms of view count since we started doing these live streams. I'm really enjoying the conversations that you and I are having. I'm really enjoying the input of our viewers. So please, if you haven't already, put a thumbs up on the video, like us, subscribe to us. For whatever reason, we can get thousands of views every day on a video, but we're just stuck at 175 subscribers. That doesn't compute for me. So share us, subscribe to us. You can find us on Apple Podcasts, Spotify, Google Play, etc. And Norm, unless something comes up, you're not going to see me until Monday. So are you going to be okay? I will be here starting to prepare my closing arguments, because I think that closing arguments in the United States of America versus Joe Biggs et al. Could take place as early as late next week or early the following week. So I'm looking forward to getting back home to New England. I missed an entire winter, but the cherry blossoms are coming out here in Washington, and it's beautiful. I bet that's pretty. Get some pictures. Will do. All right, Norm. See you Monday. Objection. Overruled. What? I don't even know what rule you're citing. Anyway, subscribe on Locals if you can as well. Norm, I've got an idea to talk to you about. I'm not going to disclose to the viewers, but I think there's something really cool that you could start doing. Anyway. No, I'm not going to get online nude. I'm not going to do it. I said cool, not sexy. Oh, okay. Sexy for an old man. You've made my day. Thanks, everybody. Come back next week. We'll talk to you then. All right. Bye.